Namaskar, lovely to see all of you, great audience here. I'm going to refer to a lot of papers because see, all of them are legal luminaries. You never know what they're going to do to me. आजकल ज़माना ऐसा है. So, you know, they all, I read about them, but I don't think it's going to suffice the time that we have. I shall also try and open it for a Q&A session. You know, I'm sure a lot of you have questions, so let's dive deep into it without any more delay. Hi everyone, Vrinda, Judge and Ashwani ji. I want to ask you, Dr. Ashwani, I was reading your book, Guardians of the Republic, and the measure of justice, as it were. I don't think there is a single definition to measure of justice. I think it's a very, very good mix of law, facts, laws, rules, plus a bit of philosophy when you talk about equity, when you talk of humanness. Talk a little about that.
Well, I think long before John Rawls gave us famously his definition of justice being the first virtue of social institutions, the idea of dharma and justice was built into our ancient texts. And finally, the idea of the nation's sense of justice is encased in the Constitution. And the principles which are sacrosanct in our constitutions are the principles of liberty, equality, dignity, justice, inclusion, plurality. So the idea of justice that I subscribe to is the idea of justice encased in the Constitution that promotes human dignity and justice for all. That is the sum and substance.
Right. Judge, you know, I was talking to a lot of people before I decided to come and do this session, and a lot of young people had a lot of questions. And Judge, when we look at the American judicial system, you know, the Indian Constitution, by the way, has also borrowed some facets of the American judiciary. And of course, there was a lot of criticism at that time, but then Dr. Ambedkar explained that how a lot of these constitutions had many such things to offer to our constitution. So ours also has a part of yours, as it were, although you are ours, Judge Shah. So, you know, I think the judicial system in America is going through, correct me if I'm wrong, unprecedented challenges in recent times. Of course, Shri Trump is one of the main reasons. I don't want to mince words. But then there is a 2024 year-end report on the state of the judiciary in which Chief Justice John Roberts commented that threats against federal judges have more than tripled in the last decade. This was a story also in Reuters, which spoke about how 600 posts on social media, which were viewed over 200 million times, were targeting even family members of federal judges. I mean, this is scary, isn't it? And this is America, where I can sue somebody because I did not get jalapeno in my burger. Go ahead.
It is very concerning. That report has been discussed amongst the judges quite a bit. Thank you so much for your wonderful question and this audience today, and my wonderful panelists. These threats have increased at an exponential level. And just for example, these threats, there was a judge in the federal court, a litigant who was unhappy with her rulings, came to her, the person came to her house and shot her husband and her son at their home. And the son died. He was 20 years old. And the father was severely injured. And then that son's name was Daniel. And then now fast forward, today what is happening is when people are unhappy with those rulings of a different judge, they will send a pizza delivery to their home with Daniel as the sender, as the name. And the message is that we know where you live, and what will happen to Daniel might happen to you or your family. And so this kind of atmosphere has made us very concerned about the rule of law and how we implement justice. I'll keep my prologue very short. The idea of justice evolves as community thinks of justice. And when our constitutions were written, both the US and Indian Constitution, some things were not considered when those were written, but today we have a different idea of justice. For example, in the US Constitution, only certain people could vote, and only certain people could own property, and that has evolved and changed. And I'll speak further. There's a very seminal case that involves a South Asian in 1923, and I'll speak to that later.
Vrinda, judicial activism. You describe most often as a lawyer-activist. And sometimes for a lot of people, they've asked me, because when you talk about activism, you also talk about sticking your neck out and talking about issues which could make you unpopular with the multitudes, as it were. Why don't you, for the benefit of the young people, explain what is judicial activism and what is it to be a lawyer-activist? Vrinda Grover.
Thank you. So judicial activism is a term that came about in the Indian Supreme Court in the early 80s when the era of public interest litigation came about. And issues that would not reach the Supreme Court but would affect a large number of people, particularly those who did not have access to justice, marginalized, underprivileged, etc., with a host range of concerns. The court said a letter, a petition, anybody can come forward and represent, and that's when the Supreme Court said our role in Indian democracy is larger than the very specific adjudication we do. And I think in this country that was much needed. We are a country that, as we know, continues to remain highly stratified, marginalized, oppressed in many, many ways and places within the country. So that was judicial activism. Today it has a very peculiar turn. Language, as we know, is today, words have either been hollowed out of meaning or they're being used in a very distorted, pejorative way, where if a judge is giving a ruling which is, in support of a certain standpoint, there'll be a lot of social media and otherwise saying, oh, these judges are now doing beyond their mandate and this is judicial activism. And we see that particularly at a point when the executive is both powerful and dominant in the country. Coming to the lawyer activist part, so I inherently believe that if you're living in a democracy, which I think we still are and we need to keep it that way, you need to be an activist as a citizen. There's no point in going and casting a vote occasionally. That's not what democracy is about or shapes democracy. Activism of thought, action, conversation. This is activism, and that's what we are meant to do. Our role is not just to go and cast a vote, although that may be now being made the dominant feature of citizenship. The lawyer activist actually is an idea that I learned from Asma Jahangir, who those of you who are younger or not from within South Asia may not know, was a very fierce lawyer in Pakistan who also believed in South Asia, a peaceful, democratic South Asia, and we were all part of South Asians for Human Rights. And Asma would always say, you need to fight, and in Pakistan they fought military rule often. She said, you need to fight for rights within the court and on the streets. So the lawyer activist is not some shrill, strange, crazy creature. It's actually combining your professional and your civil role as a citizen.
Wonderful. I know I should be asking her about Umar Khalid and Sharjeel. Yes, a lot of us want to know, but I'll come to that later because that is one question I was told to ask by several people, and I also want to know, frankly. I mean, why should I mince words? Ashwani ji, I want to talk about, judicial review. In your book, it's a beautiful book. Most of you you can get it here, Gardens of the Republic. It's a lovely book. It's a collection of essays which Ashwani ji has written. In that, you speak about judicial review, and you say that the court's powers of judicial review is validated essentially on the premise that democracy is not merely the rule of the majority. Yes, but then you say that, there are many people reject it, and they say, no, it subserves the rule of the law, that it is anti-democratic. Why don't you speak a little about that? Judicial review, as it were.
Well, the subject of judicial review has been in the public domain forever and ever. The contours and ambit of the power of judicial review have invited several comments, and my book, therefore, naturally addresses some of those points of view. There is absolutely no doubt that judicial review as an auxiliary protection, as a platonic guardian of democracy, is absolutely essential in the country, and that is why it has been made a part of the basic structure of the Constitution through a judicial interpretation. I support judicial review. I think it is necessary. But I'm also aware of the fact that in the exercise of the judicial review function, sometimes implicit in the exercise of a particular exercise of the judicial review in a particular case is the assumption that the legislature or the people don't know better than the judges do. I dispute that proposition. I have been in public life for a very large part of my life, and I can tell you that the collective judgment of the people, both in terms of policies and politics, is the preferred judgment. However, to summarize the view that I take on the question is that that it is necessary for judicial review to be a restrained exercise of judicial power for ensuring the longevity of judicial review itself. Otherwise, if the court were to come into conflict with Parliament and be in perennial conflict with Parliament, which for right or wrong is the forum where the will of the people is represented, this would lead to a disharmonious construct of the constitutional power divided between three organs of the Indian state. So these are very, very difficult questions to answer within a minute, but it is necessary to say that while you support judicial review, you must also not be disdainful of the processes of democratic politics, which are also reflected in the processes of Parliament.
Right. Judge Shah, let's now focus on how the political echo chambers, as it were, impacts even the judiciary, because you said this once, that after all, judges are also human beings. Did you? I mean, I read that entire report, and it said that, Judge Shah saying that, come on now, judges are also, they are regular guys, they are human beings. But do you think now, Judge Shah, that, the tone of political debate affecting the courts now is worrisome? I mean, it's come very close than what we thought it would.
It has, and I think this question of judicial review answers this underpinning of judges are humans. We make mistakes. We strive to be neutral and fair and unbiased. Sometimes we meet that measure, and sometimes we don't. And we have to admit that judges cannot be perfect. And so I give you an example. There was a South Asian Punjabi, Bhagat Singh Thind, who came to the US in 1913. He was fleeing sort of the British rule in India, and he was a freedom fighter, but he was being chased. So he fled to the US and came to study at the University of California, Berkeley. He was studying, and then he got recruited to go into the military, the US military. He went and he served in World War I. After he served, he applied to be a citizen. He was eligible because of his service. He was granted citizenship by a court, but the government did not agree with that decision, so they appealed to the US Supreme Court. And in 1923, they ruled that he was not eligible for citizenship. And the reason is that he was not white. His argument was that he was of the Aryan race, and he came from a long descendants of Aryan, which is white, according to the law. The Supreme Court disagreed, and they said, no, when you're white, we know what characteristics you are. You're not brown, you're not of a Sikh faith, you're of a Christian faith. And so they denied him citizenship. And because of that, he was not allowed to own property, and he and many other Punjabis in California around this time were stripped of their ownership of land. And this led to an interpretation that citizenship was only granted to white people and to black people who came from the Civil War. And this interpretation obviously changed over time. And the good news is Bhagat Singh Thind was able to become a citizen in the 1930s, and he became a professor at the University of California, Berkeley in literature.
Lovely is that? Yeah. Wow, yeah, absolutely. Vrinda, two elephants in the room, Omar Khalid and Sharjeel. I've been asked to ask you, I was recently listening to, Senior Counsel Dushyant Dave, and he speaks about how erroneous it has been, and on both when it comes to facts as well as fairness. He uses two words for it and said that, I do not know, I do not understand legally so much of, obviously you three are great at it, but judgments do not really, they're not predicated on emotions, they're not predicated on what I understand as, let's be fair, I need to get more ice cream than you do. But the point of the matter is, why don't you talk about this particular thing? And let me tell you a little thing in the newsroom where I work, not just mine, but every newsroom, we are all, it's like get, set, go, Umar ka aaj aane wale, chalo, kuch nahi hoga yaar, chalo. It's become like that, and it saddens me that we are presuming in that way, Talk a little about that, Vrinda.
So I think the elephant in the room is not Umar or Sharjeel. There are many such. We have forgotten to look at Kashmir. There are journalists imprisoned there even today, and human rights defenders. Many of them are not imprisoned there. They've been thrown all over the country. But the elephant in the room is the abuse of power and the weaponization of criminal law by the state. And I mean by the executive, of which the police and the investigating agencies are simply doing a job that is handed out to them. And that is the elephant in the room. What this judgment has done is actually, Umar and Sharjeel have been presently condemned to be incarcerated for longer, but what has it done for all of us is very important. Look at the phraseology used in this judgment. It says their speeches destabilize civic life. We are talking about an act of terrorism. Across the world, what is a terrorist act has been a matter of debate, including after 9/11. Nobody can ever come down to what is a terrorist act because it is a political space and law struggles over there. But to take terrorism and terrorist act outside the purview of violence altogether, it is nobody's case that Umar or Sharjeel or Bhima Koregaon or journalists have ever indulged in a singular act of violence. What is the problem? Their ideas, their thoughts. So what I am saying today, if it is something that the state, the ruling dispensation regime does not like, that does not make it an offense. That is what democracy is about. Nobody has said that Umar has used any act of violence. Why is he in jail? Because he's challenging decisions, actions, policies, the anti-CAA profession, the law. So many lawyers have filed petitions in the court challenging the CAA Act, which I personally believe is totally unconstitutional. It introduces religion as an element of citizenship, which we cannot have in India. So can we not discuss this, protest about it, speak about this on the streets? Why can we not? Why will we not discuss this? So the elephant in the room is what is happening to the judiciary, which thinks challenging ideas, and there was a session on free speech where Judge Shah was, the line is between protected speech and prohibited speech. You cross that line when there is incitement to violence, of incitement to imminent violence. Please read the judgment. It's a little long, unnecessarily to my view, but that's just my view. Where is the link between the speeches of these young student leaders who are Muslim and the violence that happened in Delhi? I belong to Delhi. There was in one part of Delhi. Without the link, this is protected speech. So what that judgment is not about Umar and Sharjeel. It is about us. It is about our democracy. And therefore, we must comment on it. And in my view, and it's again just my view, and there is no bar in law, because I know there is all this fear. And therefore, it's, you can call me lawyer activist. It really doesn't mean anything beyond a point. There is no bar in India to commenting upon a judgment. You can criticize a judgment. You can have a difference of view. It is not to be feared to speak about a judgment. So there is, to my mind, the interpretation of terrorism, and Terrorist Act today has thrown the door wide open for any form of democratic practice and action to be thrown into the bag of terrorism, which then makes bail impossible and then has a consequence on personal liberty.
Dr. Kumar, would you like to say about Omar Khalid and Sharjeel? Sir?
Nobody can disagree with the fact that the judgment of the Supreme Court is patently unjust. There is absolutely no reason to deny. There is absolutely no reason to deny bail to two people for more than 5 years without the trial having been even commenced.
Yes.
It militates against the first principles, not only of the criminal justice system, but also against the first principles of a dignitarian democracy. And I want to stress this part. I have always premised my writings on the view that Indian democracy is not only a libertarian democracy, which values the freedoms and liberties of its citizens. It is above all a dignitarian democracy that seeks to ensure the dignity of each of its citizens, anchored in freedom, liberty, right of free speech, inclusion, and plurality. And that is why Sharjeel Rahman's judgment is not only wrong, it is patently unconstitutional. But I want to make one point about this democracy being secured, where not in the wisdom of the libertarian institutions of democracy, not in the wisdom of the few judges in the black robes, but in the assertion of an informed citizenry which insists on protesting injustice in whichever form, wherever that injustice be. That is the message.
Right. In your book, you also talk about that we all live in an era where gossip is now gospel. I really love that thing. I mean, you start something, it's like Chinese whispers, and you quote the Gandhi's National Herald case and also Justice Verma's case. I have two questions here. Number one is that, of course, you talk about how, unless it's been proven, why is it that we run away with it and, we level charges, casting aspersions, etc. But, as an opposition, if the Gandhis, of course, are a political family, what other alternative do I have as an opposition but to kind of, resort to what Mr. Amitabh Bachchan says, fastest fingers first. I go and say, oh, you did this, I start leveling charges. Talk a little bit about that, because let me also add here, Dr. Kumar, with humility, that considering I'm a journalist, I mean, the Karnataka government has given its ads, 69% of its ads to National Herald. The paper has no circulation in Karnataka. It's absolutely zero circulation. So there is what is called political nepotism there as well. Dr. Kumar.
Well, I'm not a spokesman of the Karnataka government, and I do not know whether it was right for them or wrong for them to spend public money on giving ads to National Herald. That is an entirely different subject. But as far as the accusations in a criminal trial are concerned, be it the National Herald case, be it any case, National Herald is only an example of that. even before the charges are framed, the spokespersons of the government come, hold press conferences, discuss the merits and demerits of the case, which is a function of the court, not of the media, not of the political parties, through political press conferences, trying to create a public perception of guilt long before the judicial process has even started. That offends against the basic rules of fair trial. And fair trial has been held by the Supreme Court itself to be a part of the basic structure of the Constitution. So what do you say of a situation in which the ministers of the government, holding high positions, in order to win the political battle of perception, violate the legal due process and then swear by the Constitution? That is what I object to.
Can I just jump in for half a minute?
Sure.
You know, we talk of the National Herald case. I don't belong to any political party, so one can have an independent view. Whatever cases we talk of, let's talk of the cases that are not getting lodged. Let's talk of the cases of hate speech that happened during, and it was hate speech, it incited violence, that happened Delhi 2020 riots, which were never lodged. They are today ministers in my state of Delhi, because they belong to the BJP. So we will talk about cases that are lodged, but sometimes it's what's the omissions that are equally important. You have today a criminal, I will not call it a criminal justice system, it's just the criminal legal system, which is today has been totally distorted and controlled. What is at risk is people's confidence in those legal institutions. We are a very complex country which has multiple concerns and interests. What is the mayhem we are headed towards?
Right. But then this also, I mean, I'm also jumping in for 10 seconds, Vrinda, that you talk about them being ministers who made, who used cuss words, like I heard their speeches. But it happened during 1984 as well. We remember Sajjan Kumar, we remember, Mr. Bhagat, everyone. But this has been part of our system. That it's all
Sajjan Kumar is today Sajjan Kumar is today in jail.
Yes.
Many of us actually worked on the 84 cases and got them behind bars.
But it took decades, right?
Yes, it did.
Those often...
So maybe people should remember now that law and some of us may be pursuing this for a long time.
Yes. Jacha, even as the Trump administration, it seeks to deliver on the president's campaign promise to enact the largest deputation program. I was reading through it, and what really struck me was that the federal government said that some of the deputations occurred because of the confluence of administrative errors. Do you want to talk about it? Because how do you change a person's life because there is an administrative error, for God's sake? How do you do that? Unless there is some kind of, mischief behind all this and you're trying to color it with, oh, it's an error, let it go. Yeah?
Excuse me. This is a problem that the judiciary has been grappling with for the last year, maybe even 2 years. This idea of due process and being fair. And when the executive branch decides to take action that many people object to, then it is the courts who act as the barrier to prevent this from happening. But our judgments, our orders, are only as good as if people follow them and they have trust in what the work we do. My panelists talk about how there's a distrust sometimes when the judiciary is not consistent, when they make decisions that are flawed in their reasoning. And what's important is that when judges make decisions, that they be checked, that there be a process of check and balance so that these executive orders and judicial decisions can be debated and can be make sure that they're fair to everybody. And for deportations, people are very upset. They're protesting right now because they feel like it is an unjust exercise of power, and that is something that the judicial branch takes very seriously.
Thank you, Jacha. Vrinda, the BENS, and I've heard you speak about it. You say it falls short of making the state accountable. You've spoken about how the BNNS is regressive, and we, the people of India, have been reduced to being mute spectators. I mean, this is for a lot of people scary because we are living in this era. We were all there when it was introduced, you know. Talk a little about it. Why do you think it's regressive more than anything else?
So BNS, for those who, is the Bharatiya Nyaya Sanhita, which is the new incarnate of the Indian Penal Code. We were told this exercise needs to be done because we are an independent republic, constitutional republic, and this is we need to decolonize our laws, and we shouldn't remain Lord Macaulay ke bacche. We are speaking in English, we can speak in other languages, it's just that we won't be able to communicate with each other. So yes, the decolonization of laws should have taken place actually when the Constitution was passed in 1950. I don't have a disagreement with the principle, but was the law decolonized? I'll give you 3 to 4 examples and you can make your own assessment. The shortest chapter in the Indian Penal Code was offenses by public servants. Of course, it's a colonial regime. It's not going to put its public servants at risk. And they are given legal immunity. You cannot prosecute a public servant, be it a minister, a bureaucrat, a policeman, unless you get prior sanction from the state, even if it's an extrajudicial killing, what we know as encounters. One of the smallest chapter in BNS is offenses by public servants. The legal immunities that they enjoyed during the colonial period continues and has been further reinforced. As some of you may know from the newspaper, it is given in perpetuity to the election commissioner, the chief election commissioner and the election commission of India, for reasons you can well figure out. So the public servant in a constitutional republic remains somebody who's over and above us, although we keep using the word servant, so they're in service of the people. And we know that there are many acts that are done. A very different example. Due to Victorian morality, abortion and Christianity, abortion was criminalized under the Indian Penal Code. The MTP Act, the Medical Termination of Pregnancy, carves out an exception so that the doctor who performs the abortion is not penalized. You don't have a right to abortion in this country, that's a misnomer. You can, in certain circumstances, access abortion. Abortion, voluntary termination of pregnancy by a woman, there are judgments after judgments which will talk about sexual autonomy, bodily integrity, blah, blah. It continues to be criminalized under the BNS. Under IPC, sedition, again a British hangover, required for colonial rule, was an offense, tailored down by the Supreme Court through its judgment to make the link between violence and speech, which will be prohibited or criminalized. Look at the new section 152 in the BNS. It has actually exploded and expanded the scope of what will be prohibited criminal speech. So where is the decolonization? And there are multiple such examples that I can give, but we don't have time. So simply, that's why I said in the beginning, words don't have meanings, or actually you're supposed to hear them carefully because they're probably doing exactly the converse here. We haven't decolonized the laws. We had to align them with the rights and freedoms which are inherent in us as citizens and make the state accountable. We don't see that happening even now. And one last, because you did mention that in the introduction of Dr. Ashwani Kumar. The National Human Rights Commission, and anybody who has any experience, exposure, torture is pervasive, endemic, and rampant by the police and other officials in this country. Why have we not made torture a criminal offense in this country? Does it hurt the government to make torture a crime? It will help us.
I just want to say something on this because it takes me to a very important point which I had to make but I couldn't make because the question was not framed accordingly. Vrinda mentioned about the absence of an anti-torture law. I was the chairman of the Select Committee of Parliament that proposed such a law. The law could not be passed when this government came, I filed a public interest litigation to the Supreme Court in 2015, where in 2026, the matter is still pending in the Supreme Court, and the Supreme Court has not been able to pronounce upon it. Then I filed a petition for the benefits to the elderly people, the right to dignity of the elderly. A writ was issued in my favor by the Supreme Court in 2016 or 18, sorry. We are now in 2026. It is a continuing mandamus. It is pending in the Supreme Court, and it has still not seen the light of the day. The point I'm trying to make is, when you discuss the measure of justice, somebody said that look at the cases that have not been filed. Look at the cases that are pending in the Supreme Court, which concerns crores of Indians and have not been decided. That's the level of injustice that we see being perpetrated within the precincts of the Supreme Court. So therefore, the measure of justice has to be tested on several touchstones. And I wanted to make this point only to say that please do not leave all your liberties and pin all your hopes in any one institution of India's democracy. That hope must be in the quiet and not so quiet assertion of the people of India in favor of their rights.
I'll come to you, Judge Shah. I have to ask you, but Vrinda, you spoke about NHRC. You worked very closely with the NHRC. Used to, yes, but I'm going to, when recently, I think a Delhi schoolboy died by suicide, and you said this about the NHRC. And let me quote, the NHRC has gone very silent on issues of injustice, human rights violations that are deeply concerning today. We learn about them through media reports, but we do not see the NHRC being a responsive, proactive institution. And that really is very, very bothersome. Speak a little about it. When did the change happen? Have they also been, I'm going to stick my neck out, being sold out, as it were?
I don't think it's a question of selling out. Actually, that's the easy answer. And I think the problem is much more complicated and difficult. You have the NHRC, which, when Justice J.S. Verma was the chair, he went to Gujarat in 2002 when there was a massacre of Muslims taking place. They not only did a whole set up committees over there, but actually went to the Supreme Court and asked the Supreme Court to intervene, which the Supreme Court did. And then the rest, as we know, is history, what happened decades later to the activists being penalized for helping people in distress who are being targeted by state violence and mob violence. So the NHRC has, in fact, NHRC, I remember in the days when they used to consider human rights. Now NHRC has actually, in one of its annual day lectures, we were told that human rights is a Western concept. So I'm not sure what they're doing, because their statute says they're supposed to work on all human rights. It's the very statute that founded the NHRC in this country. The NHRC has actually presented a report on why torture should be made an offense to the United Nations. The NHRC today has been downgraded. There is a complex process at the United Nations where all human rights commissions are given grades. India used to enjoy a very high grade. That has been downgraded. If the NHRC, the way it works now, and this is true of most commissions, unfortunately, and these commissions came out of a lot of public demand and public activism. If the commissions start aligning themselves to what the state likes and the interests of those in power, and therefore if you want to see what is happening to the NHRC, you can actually draw a parallel with what is happening in the political executive. Having said that, let me remind us that putting those people in positions at the NHRC or all other commissions is not something that's peculiar to this particular NDA BJP government. Justice Ranganath Mishra, since you mentioned 1984, a massacre of Sikhs that I witnessed personally in Delhi, Justice Ranganath Mishra did a complete sham job with the first commission of inquiry on 1984. He was then made the chair of the NHRC. So this is something that parties in power do. And therefore, today, people don't turn to the NHRC for policy advice, for intervening in larger patterns of injustice.
Right.
One person dead here, those are all terrible tragedies and injustices. The NHRC's job would be to map patterns of impunity, patterns of discrimination, and then provide answers, hold power to account. None of that is happening, and I don't see it happening till there are shifts in the political terrain.
Judge Shah, my apologies to you because I have to open it for questions, Your Honor, if you give me permission to do that. Okay, time for 3, and let me announce it right here, let me be fair. I've got 2.5 minutes. So please desist from giving opinions, comments, long-winded questions, very, very short. Please, now it's 2 minutes. I've spoken so much. There's a hand which has gone up there, waving at me, I think wearing a pink muffler and a hat. Please stand up and identify yourself. Please take the mic to the person. Quickly, please. Thank you.
Hi, my question is for Ms. Grover. Ma'am, when you take such a strong stand, clear stand, and you deliver what you really want to say, which is amazing in today's times, I just wanted to ask you that does being a woman, is it held against you? Does anybody use this as something, to take away from your penetration of the subject?
All right.
And if they do, how do you deal with it personally and professionally?
Thank you. Go ahead, Vrinda.
So yes, being a woman lawyer, particularly on matters like this, is not, although if you look at all social justice movements in the country, they are led by women. And there must be a reason, but I'll leave it for others to think about that.
Yeah, go on.
It's a difficult profession for women lawyers to make their place, particularly when you do this kind of thing. I think we'll reach there. And yes, many in the profession, including judges, they try to put you down. It's really all right. I wouldn't waste my time. Just remember, you right now have only one judge, woman judge in the Supreme Court, and the attention paid to women is less than tokenistic. It's not about me as a woman lawyer, it's about concerns of women. How are they approached? There is too much, and this is happening within law and it's happening within politics. Everybody's talking about women, but there is no freedom for women.
Lovely. Go ahead, young man.
When law and justice contradicts, which one would you choose?
What? Say that again.
When law and justice contradicts, which one would you choose?
Well, I'd like to answer that question because, and I'll answer it in a very fine phrase. A Supreme Court judgment of Justice Krishna Iyer, which has been followed in several other judgments, says the mortality of justice at the hands of law. So sometimes the pursuit of procedural law can lead to an unjust result. In such a situation, my answer to you would be, law must yield to justice and not the other way around.
On that note, thank you for being such a wonderful, I'm so sorry, but we've completely run out of time. Thank you for being a wonderful audience. Thank you very much. Thank you, Dr. Ashwani Kumar. Thank you, Judge Shah.
Thank you.
Thank you, Vrinda. It was fantastic.
Thank you
so
to
many
everyone on the
questions,
panel.
But then, time. Thank you very much.